Brock is doing an amendment on the interrogation bill.
Okay.
So I think they're going to pass over it today.
That is what Senator Burris just told me.
Some of them, I don't know what Senator Brock's about. He spoke to me yesterday. Anyhow, I told him I wouldn't be speaking on the floor or anything else unless I'm absolutely required to. So we're going to walk through page 694 and activate to sexual exploitation of a person under the supervision of the Department of Corrections. So Michelle, I thought we did this a few years back.
You did. Then there have been a few little tweaks in that time. So for the record, Michelle Child's Office of Legislative Counsel, and we're taking up H694 is passed by the House. So you're correct. We have, and you'll probably remember the other sexual exploitation crimes that are in Chapter 72, which is sexual exploitation of a person who is in the custody of a law enforcement officer, and also sexual exploitation of a minor. And that was a statute you passed several years ago having to do when you have a minor and someone with at least 48 months age difference who is in a position of power or supervision over that child. So so the proposal in 694 is to make the same change to each one of those statutes, and it goes to the specific issue that y'all dealt with in S278 around comparative negligence. And you'll recall in that discussion, when you were trying to figure out like the conduct that was involved, the sexual conduct that was involved, and there was a discussion about what terms do you use. And you landed on referencing the term sexual act as defined in 13 VSA 3251 and sexual conduct. And that definition not as used in Chapter 72, the sexual assault statute, but as used in Chapter 64 for sexual exploitation of children, that is a little more comprehensive. And so, so if you recall back in 278, you use those two because working together, they covered the kind of breadth of sexual conduct that you wanted to encompass in 278, and the same policy underlies the changes in 694. So if you look at Section 1, the first section is regarding sexual exploitation of a person under supervision of DOC. And you'll see under current law in subsection A, the prohibited conduct is just for a sexual act. And I think, as you know from your previous discussions on S278, there are certain types of conduct, I would say specifically like hand to genital conduct, that is not encompassed within the definition of sexual act. And so there's the additional language that's added in this section. I also just referenced the statutory citation for sexual act that's in there, and then it expands it also to include sexual conduct as defined in 2821. And then you'll hear from DOC talking about why they feel as though having it limited just to sexual act is not in keeping with what they are required to be doing under federal law. So page 2, same change is made with regard to sexual exploitation of a minor. So currently that just applies to a sexual act. So the same language is added, providing the reference to sexual act as well as the inclusion of sexual conduct. And then on page 3, same change is made in section 3. So that, ironically, the General Assembly recently changed from sexual act to sexual conduct, but then now for consistency's sake and because there's we kind of seemingly need to use those two definitions in concert to one another, sexual act is added back in there, but sexual conduct remains. And then the act takes effective on passage. And I did email you a link to those specific definitions so you can reference those easily.
You did?
I did. Yep.
I didn't.
I did it
emailed.
It's okay, I did it this morning, so.
Oh, okay, all my emails have dealt with S-258 and S-18. And it's hard to find any emails that somebody else sends me. It's unbelievable. There you go. Why don't I just forward this to Ben and have him print it out both? All right? Ben, I'm just sending you Michelle's email. Could you print out sexual act and sexual conduct for the committee for this bill?
And then those links go to the whole statutory section, so if you want to just make it shorter, you could just copy from
Just copy them.
those, the specific definitions in there. There's no way to kind of provide a link to just the subdivision.
No problem.
Thank you. Any other comment, other questions for Michelle? If not, our next witness is, well, not here. Oh, see it, Isaac Name, Executive Director of Policy and Strategic Initiatives of the Department of Corrections.
Hi, good morning, Senators. For the record, Isaac Gaynham, the Policy Director at DOC. So thank you to Legislative Council for giving an overview of the bill. I understand, I think there's a lot of different definitions floating around. We talked in House Judiciary a bit with Chair Lalonde about doing, I think, maybe in future sessions, some statutory cleanup of a lot of these different definitions, trying to align them a little further. But I do want to, make it clear that we are talking about definitions changing, in this case, really just one word, sexual act and sexual conduct. But those definitions matter and they have real world implications. And so what I mean by that is that in the Department of Corrections, we've had more than one instance of sexual abuse that we haven't been able to bring charges for under this current statute because it didn't meet the definition of sexual act. Because when you look at sexual act, as defined in 13 VSA 1375, and then again 3251, that's a penetrative standard. And so I also, just want to give a warning as well that we're going to be talking about rather graphic, depictions of sexual assault for those watching. This can be troubling material. But the Department of Corrections is, putting forward this change because we think sexual conduct is a more inclusive standard. It also includes non-penetrative sexual abuse. And again, we've had instances where there wasn't penetrative conduct, but we want to be able to hold former employees of the department to the standard of the highest possible legal standard. This is also important because we are trying to create statutory congruence with the standards articulated in PREA, the Prison Rape Elimination Act. So PREA is a 2003 federal law passed unanimously by Congress on this halcyon days when Congress was a little more functional. Under PREA, signed into law by then President George W. Bush, it does put forward non-penetrative sexual conduct standards. And that language also includes some intent language, which I'll talk about. But I believe those are posted on the website. That's section 115.6 in the PREA standards, which you should have access to.
The committee should also have printed copies of the course.
Thank you, Ben. So the department is, I think, very proud to put forward this legislation. We hope it won't be too controversial. In the House, they kind of decided to cover all of the bases by using both sexual act or sexual conduct. So if it meets either of those definitions, it could be prosecuted under 13 VSA 3257 in the version that's proposed here. I think we're okay with that. I know the state's attorneys had some questions around the intent language that's enshrined in 2821, the definition of sexual conduct. I would just point out that the definitions of sexual abuse as articulated again in PREA the federal law does include that intent language. So I know that might make prosecuting sexual abuse and questions of intent a little more difficult perhaps, but we're trying to close that loophole to make sure that we're aligned with federal law. It also, I think, you know, and my colleague from the Department of Corrections, so I think it's currently stuck in traffic, but is on her way here, can talk a little bit more about how this would make training easier for our staff. We talk a lot about training at the Department of Corrections. It's a really critical time to make sure folks are coming in with, you know, the appropriate framework for this very important work. And this would make it easier for folks to understand what state law is, what federal law is, that they're aligned, and also would, I think, have a big impact on staff morale, because our staff want to see folks who do wrong held accountable under the law. So this would, I think, help improve staff morale in cases where folks you know, are perpetrating this kind of sexual abuse. So I'll stop there. Questions?
I think I have either a question or just a general comment, maybe for you, maybe for the committee or Michelle. But I'm looking at sexual exploitation of a minor on page 2, and I'm looking at lines 9 and 10. And I'm curious as to the background, as to why the actor has to be at least 48 months older than the minor, and be in a position of power. You know, I mean, like, I guess my question is, you know, if somebody is 3 years older than the minor and they're in a position of power, would they not be able to be charged under this section?
So this statute was enacted specifically, even though it doesn't limit it to persons who are 16 and 17, but generally is targeted at minors who are of the legal age to consent to sex, but there is an age and power differential because of the relationship between the minor and the person. So it could be a teacher, it could be a coach, or something like that. Whether or not, you know, if there was let's say a 17-year-old and a 20-year-old and, you know, wouldn't meet this particular statute, depending on the circumstances, it's possible, you know, that there may be something else. But for purposes of the sexual exploitation, it has to be a 4-year, at least a 4-year minimum age difference, because the committees, the judiciary committees, when they had originally enacted them, had discussed a lot, you know, to try to avoid something where you might have a, you know, 17-year-old senior in high school with maybe a 19 or 20-year-old coaching assistant or something like that, and they made the policy choice not to include that.
Right. Thank you.
Or a janitor. I remember the discussion.
Yeah.
Senator Nick had brought up janitors.
And just to be clear, Senator, the Department of Corrections is really just testifying on 3257.
No, I just wanted to bring it up anyways because it caught my eye, and I figured it wasn't, that particular thing wasn't in your purview here, but thank you.
So, can you give us an example where current law didn't work?
Yes, I do want to be a little careful about details of any cases, but for example,
certainly don't need names or even geography.
Certain masturbatory acts we've seen in the past where there's clearly a power dynamic, you know, a member, a DOC employee, you know, using that power dynamic in that way. So not a penetrative act, but clearly an instance of sexual abuse. Voyeurism as well. And you'll see the PREA definitions also do discuss voyeurism.
But aren't the officers required to do a strip search?
Yes, that's a good question, Senator. So the PREA definitions do have a clause, it's quote, unrelated to official duties. And that's where the intent language also comes into play. Because obviously in those instances that there would not be an intent to perpetrate sexual abuse. That'll be in the line of their official duties.
And part of that strip search would be body cavities as well?
No, the department does not perform cavity
Does not
searches.
do
Those
that?
are performed by a qualified medical professional at the hospital.
Well past doesn't do
No, we don't do them in the facility.
it? Okay, that's, I think they used to.
We do not do them anymore.
Okay. Well, good to know. Anything else you want to add?
I do. I would just also note that 3259, you might remember Act 46 last year, S33 as part of that miscellaneous judiciary bill. The definition was actually amended for law enforcement, but it was never amended for the previous two sections. So we just, trying to create that alignment.
All right. Next we have, are there any other questions? Thank you very much.
Yeah, thank you, sir.
Next we have Jen Sparkle.
She was stuck in traffic, but she's walking up the hill now, so she should
Pardon
be
me?
here shortly.
She'll be here shortly.
Yeah, she was stuck in traffic.
Okay, can we, Marshall, are you ready? And Abel?
Yes. Thank you and good morning. Marshall Paul from the Office of the Defender General. This bill we oppose for some very simple reasons. First of all, we think that it's not it creates confusion when what we do is pull definitions from two different places that were designed for different things that actually greatly overlap with each other, but only slightly don't overlap with each other, and sort of push them all together and say, this definition or this definition or these definitions, that gets complicated and it often ends up with some unintended consequences. It makes me think, for example, of the listed crime statute. We have a listed crime statute that's used throughout our statute, but just to reflect sort of a list of very bad crimes. But its original purpose was to be a list, was very simple. It was meant to be a list of offenses for which you were entitled to a victim's advocate, and any other offenses you were not. Over the years, that list has then been pulled and used in various parts of the law, and that's led to unintended consequences because that list was designed with a specific purpose in mind, and it's not necessarily the purpose that the other places in law that use that list had in mind. And we have the same concerns about this. The definition of sexual act in 3251 and the definition of sexual conduct in 2821 very much overlap with each other. There's a lot of conduct that would be covered by both definitions. We think that's just frankly kind of a sloppy way to write this. And what we really should have, if the idea is to include some non-contact sexual behavior in these statutes, is to write a definition for these statutes that includes exactly what we want contained in the definition for these statutes, rather than trying to pull from two different statutes that define things for two different purposes and, as I said, have a lot of overlap. We also just have a general concern with the over-criminalization of consensual but wrongful sexual activity. So this applies largely to, for example, the 3258, the sexual exploitation of a minor statute. That's a statute, so if somebody who's in a position of power coerces or forces or threatens somebody and uses that in order to have sexual conduct with that person, that's punishable as sex assault no consent under 3252, which has a penalty much greater than the penalty that's imagined here. So what this really addresses, because all of that's already criminalized, what this criminalizes that's not already criminalized is the stuff that is non-consensual, that doesn't involve threats, that doesn't involve coercion.
I mean, it's consensual.
It can involve consensual relationships. And they may be relationships that are wrongful because of differences in power dynamics, but those are not traditionally criminalized. For example, As a lawyer, if I were to have a relationship with a client, that would not be illegal. I would not, I'm an adult client, consenting adult client. That would not be illegal. It would be wrongful. I would lose my job. I would very likely lose my law license. If you look at the Professional Responsibility Board's list of decisions, you can see where people have lost their law licenses for exactly that conduct. But it's not made illegal. Same, for example, if just another example, if someone in a supervisory position in state government has a relationship with somebody who works under them, that's wrongful, that's grounds for termination. It is not necessarily a crime. Typically, the way that we handle wrongful but not non-consensual sexual conduct is through means other than criminalization. It's through, usually an HR process or a licensing process or a certification process.
But that section is about a minor. Isn't there an additional responsibility there to protect the minor?
Minors can consent to sex. Anyone over the age of 16 can consent to sex consensually with anyone they want to of any age. Up to minors, a 16-year-old can consent to sex with a 30-year-old, and that's completely legal unless they fall into one of these categories.
Senator, or did that?
Well, I was just pointing out the examples you were giving were of adults and how adults might be treated by the criminal courts and statutes and their professional boards, but it's a little bit apples and oranges because we're talking about the section to do with minors.
Well, to change my example, and not that this would ever happen, but if I was as a lawyer to have a sexual relationship with a 17-year-old client of mine, that would still not be illegal. A 17-year-old is allowed to consent to sexual activity with an adult. It would cause me to lose my license. It would cause me to lose my job. The same would be true, for example, of let's say a 22-year-old teaching assistant and a 17-year-old college freshman. We have a lot of 17-year-old college freshmen these days since Act 77 and the personalized learning plans went into effect, and a lot of people are graduating from high school at younger ages. We have a lot of 17-year-old college students, and a 17-year-old college student having a relationship with a 22-year-old teaching assistant, if clearly wrongful, would probably result in disciplinary consequences for that 22-year-old, but not illegal under any statute. Other than this is what makes it illegal.
Yes.
But it is consensual, it's just wrongful. And that's where our concern is, that this is it targets a few different professions that aren't targeted, it targets police, it targets corrections, and it targets people who.
But Marshall, if I could, I feel like what you're saying, it's legal except for this law. It's not legal because of this law.
Right, and what I'm trying to say is that this narrow category of laws criminalize consensual sex, which is something that we don't generally do.
But on the same token, we have criminalized sexual conduct for law enforcement officers.
Yes, and that's, if you ask us if we supported that, we would say no. We think that essentially targets law enforcement.
Pointing out that's what.
Absolutely.
The law. Senator Seaman, Senator Paul.
Thank you. I understand the analogies that you're drawing, but I think there's, at least in my opinion, I feel like there's a big distinction between a supervisor in any job having a relationship with one of their employees consensually compared to a corrections officer who has a significantly different power dynamic with an inmate who is, confined to a cell. I feel like consent can't really be genuine in that type of dynamic. So I just feel like there should be a pretty clear distinction between those two types of power dynamics. And the other piece, I think you were describing that there's a lot of overlap between sexual act and sexual conduct. And I might be comparing two wrong sections, but I mean, when I look at sexual act under 3251, and then I look at the acts compared to 2821, especially in subsection B, it seems like there's a lot of acts that are covered in 2821 that wouldn't be covered in 3251. And so I'm wondering if I'm missing something, or can you provide more clarity? Because you said there's a lot of overlap.
I think there's a lot of overlap. If you look at 2821 section 2B, any intrusion, however slight, that mirrors a lot of what is in sexual act under 3251 subsection 1.
I'm sorry, I meant if you look at the following sections, I'm sorry, I read the wrong one. I was talking about sections C through G, essentially.
Certainly. And so I would agree with you that those are two sections. Like I said, this is one where there is overlap, and there's also areas where there's not overlap. And our concern in part is just sort of the sloppiness of pulling together multiple definitions that overlap with each other, that weren't written specifically for this section, and trying to make them fit this section instead of just writing a definition for this section that contains what we want prohibited in this section, without, using two different sections, two different definitions, looking at the overlap between the two, because there is significant overlap. And I agree with you, there is significant areas of non-overlap. And that's where these things get complicated and confusing, is when we are pulling definitions from section to section and not simply writing definitions that meet the intent that we're trying to reach here. And we've seen that happen in other cases where we've used the listed offenses to mean one thing, and it's been an under-inclusive list for certain purposes or an over-inclusive list for other purposes. From our perspective, it's better to draft when we're writing a law and we want to prohibit something. It's better to draft language that's specific to the legislative intent that is trying to be accomplished than to be pulling from different parts of the statute.
Thank you.
Senator Bohowski.
Yeah, I certainly agree that there's an underlying need to perhaps update the laws that define sexual acts, sexual conduct, and sexual assault. And I think that perhaps in the future, that is something we should consider doing. The question I have for you is if you see a fundamental difference between someone in a supervisory role where maybe I'll lose my job if I don't engage in that versus someone who holds my freedom interests. I might go back to jail if I don't engage in that.
And I think that there's two different levels of coercion and threat involved there. So if somebody says to you, engage in the sexual act or you're going back to jail, that's a threat, and that is covered under 3252 A1 or A2 as sex assault, no consent, and that's punishable by, if I recall, I know the maximum sentence must be life. I think the minimum can be as low as 3 years. But so that's already punishable under a section that has very strong sentencing.
No, I understand that, but I think sometimes when it's my freedom interests at stake, there's an implicit understanding that that could be the outcome of me not engaging in what I've been asked to engage in.
And so that would be coerced consent, which also falls under 3252 as sex assault, no consent. Coerced consent is considered no consent in our statutory scheme.
Well,
So-
go ahead.
So then, would any instance where someone in the role of supervising an inmate be coerced consent because I, as the person on probation or parole, could reasonably assume that could be an outcome of me not engaging in the behavior I'm being asked to engage in?
It would certainly depend on the facts of the case. I mean, I can tell you that I'm aware of situations that have definitely been consensual. In speaking to people who are engaged in those relationships. I'm certainly aware of where, you know, based on the actual facts on the ground, it was consensual. There can be power differentials in relationships. There often are power differentials in relationships. Just in normal relationships, there exist power differentials. People who have disabilities, we don't say that they can't be in a relationship with someone who doesn't have a disability, even though there may be a power differential between the two.
So I feel as though Senator Hashim had it exactly right when he was saying that someone who's imprisoned doesn't have the power to consent. So, you know, when you say that there were instances where there were facts on the ground where it was consensual, I would just dispute that.
I wasn't talking about anyone who was in prison.
Okay.
That was someone who was on outside community
If someone is,
supervision.
if someone is with someone who's wearing a gun, who's talking to them, if they're corrections officer and they're talking to them, the kinds of situations that we're talking about, I think the power to consent is fatally undermined by that power dynamic, because it isn't the same as being an entry-level administrative assistant in an office where the boss shows attention. It's a fundamentally different thing involving the use of loss of liberty and potentially, you know, the person has the ability to use fatal force.
My understanding, I don't believe probation officers carry weapons.
They carry the weapon of sending you back.
There is a bill in
There's a perpetual bill to try to allow them to, but my understanding is that they don't carry.
But there's still a power dynamic between the corrections officer or probation officer and the individual who's in the community. They have the power of arrest, they have the power to cite, they have the power to set certain rules, you know.
Let me give another example. A doctor who has a relationship with a patient, that can be completely wrongful, that can result in them losing their job, losing their license. A doctor very much has power to cause someone grave harm by either mistreating their conditions or undertreating their conditions or overtreating their conditions. And we don't do the same thing with doctors. We allow that profession to sort of police itself. We don't allow
But again,
law enforcement to
it's
police
apples and
itself.
oranges, because you're not legally required to go to a certain doctor. You are
No,
legally
Dr.
required.
Nasser, whatever his name was.
Yeah, the team doctor, but that was to stay on the team. But I'm just saying that I think we're engaged in a little bit of silliness here, because these are not commensurate situations at all.
Well, and I think, while I appreciate we have statutes around threats and implied threats, I don't think that someone in the position that could send me back to jail has to say or even imply that that is a possible outcome for the person on probation to believe that it could be a consequence of not engaging the behavior. And so I worry that the statutes we have that get at threats or implied threats actually don't cover and protect people as much as that it needs to.
Well, so just to get, I want to kind of circle back on my testimony to say that, you know, because we're not suggesting here that we should be striking these bills, these statutes. We haven't
Sounds like it.
proposed
Thank you for that.
legislation. We haven't proposed legislation to repeal these statutes or anything. We're simply saying that these types of statutes where we are criminalizing what we would see as sometimes consensual sex. We don't like seeing that because it seems unequal in how we treat different categories of people, because there exist lots of different power dynamics. I mean, people get into relationships for all kinds of reasons, some of which are good and some of which are bad. And typically the legislature only criminalizes the ones that are non-consensual, not the ones that are bad for other reasons. And this is just one narrow area where certain professions and certain people have been carved out and said, we're going to treat you differently. If you engage in wrongful sexual activity, it's going to be a crime, not an HR problem.
But they're your clients too, right? Your
Yes.
clients are very often the people that are the subject to this behavior.
Yes.
So I guess my question for you is would it make more sense then from your perspective to look at our consent laws to make it so that individuals in this type of situation can't consent?
Okay.
I don't, to answer that, I don't have an answer because from our perspective, it's fact-based and there are situations where it has I think anybody who knew all of the facts could look at it and say, yes, that was a consensual relationship, even though the power dynamic existed. And from our position, it doesn't make sense to say that something is non-consensual when factually it is consensual.
Other questions for, thank you, Marshall. Appreciate it.
Thank you.
Our next witness is Jen Sparta. Sorry if I.
It's okay, it happens all the time, so don't worry about it, it's Spracky.
Spracky, okay. Spracky.
It's okay.
Thank you.
No, thank you. The first thing I want to say is you guys clearly, so I'm the Prison Rape Elimination Act and Constituent Services Director for the department. So sexual abuse and sexual safety and confinement and our system is my job. And so I just want to say that I may have written a note and said, I love these guys because your awareness of consent, force, implied threats is the heart of sexual safety in PREA. And so a couple of things I want to make clear is when PREA was passed in 2003, it actually declared in federal statute that there is no such thing as consent in a confinement setting. It's very specific to that. And then it was up to each state to actually make it illegal. Vermont didn't make anything illegal until 2006. And our law was very prescriptive. A couple of years ago, we expanded it to remove the language of direct supervision as defined by on the caseload of. And so where I absolutely agree is that we agree that there needs to be consistency in language, if it doesn't make sense for it to come out of that fund, we don't care where it comes from. But one of the things that we are noticing with our cases is that the language is too specific when we only talk about penetration. Because oftentimes when these acts occur, it is other acts. So for example, if a staff person says, do this or I'll rape you, that is already covered in the law because it's a penetrating act. But what isn't covered is do this, perform a masturbatory act on me. That's not covered. And we have run into issues where that is the stuff that staff are engaging in, that is the stuff that is being reported to us, or that is the stuff that law enforcement and state's attorneys are actually able to substantiate. And without the update of this law, we will not be able to prosecute folks. And that happened a couple of years ago out of Brattleboro, where we were not able to, pursue charges because of the specific behavior that folks engage in. So assuming that all sexual acts are only penetration is foolish, because that's not actually, it's not like, hi, then we're having sex. There's lots of behaviors that occur beforehand, and we have a lot of eyes, and there's a lot of stuff that we see, and what we're trying to do is actually support our staff when they're making those reports early on so that we don't have victimization, so that we don't have a penetrating act. And while I absolutely agree that it is an HR issue, it is also a state issue. These folks are remanded into state custody, and there's a difference between supervision authority and liberty interest. And the reality is that it's not just about, I can send you back to jail or not. If I'm a person who's a violent offender or in mandatory programming, a DR can make me stay in jail. Just a DR.
It's a DR.
A disciplinary report. So if all I have to do is say this person threatened me or tried to assault me, and now it's your word against mine. And we already know in the system that the general approach that folks have is that folks under our custody that are incarcerated or under field supervision don't tell the truth because they have a history of not telling the truth. But that doesn't mean that when it comes to victimization, they are not being truthful. But the system is already against them, and it's already for staff because we have to tell the truth. So the assumption is when a staff member makes a report, they're telling the truth. And there's a very early on video that the federal government put out, the National Institute of Corrections, in which there was a gentleman who was a former Marine. He had been wounded in service. And he had a drug problem. He then turned into stealing so that he could support his addiction. And a staff member propositioned him. And what he said in this video is all he has to do is rip his shirt and say, I did that, and I'm gonna get 10 years, because it was in Florida and a staff assault is a mandatory 10 years. That's not Vermont. That's not the way our system operates as far as the 10 years go. But that fear and that thought is a real thought for the folks in our system because we impact everything. And they know that they have the lesser word. And so what we're asking for is the ability to protect the folks that you have put in our custody and told us to protect. And in order to do that, we need to be able to hold folks accountable to the highest standard of the law. We do not pay staff to have sex. And we don't pay incarcerated individuals to have to turn down propositions and dates. Our job is to make sure that these folks come in, they spend their time, they get whatever services they need, and they leave better. And having to manage relationships and propositions and any type of romantic interest is not what they're there for. And that's not what we are paid to do. And so our staff know that, and it is so frustrating for them when they see their colleagues no longer employed by the department, but then what they don't get to see is that criminalization where they're held accountable. We have, another case where an incarcerated individual is victimized and the first plea deal was 90 days. That's what this perpetrator is gonna get, is 90 days for sexually assaulting someone in a facility. Because the exact issue that I listened to in court was an argument of consent. And I said to the state's attorney, it doesn't exist. And the answer was, well, Vermont law is different than federal law. And I said, but it shouldn't be, is my answer, because that's what the department pays me to say, and I believe it, it shouldn't be. If you are incarcerated, it's our job to make you whole as we can. Sexual assault and rapes does not make you whole. That actually wrecks you and that tears you apart. And we want to make sure that we have the ability to hold folks to the highest standard. Yes, ma'am.
Wow, Senator Bowski.
Does this language so it's kind of messy. And that's, I think the underlying statutes are kind of messy. This has come up in a couple other places too, as council spoke to another bill we worked on this year. Does this language get you to the place you need to be, or is there a way that we could better get you there?
It does, and I'm going to look at Isaac and Haley too, because what we did is we looked at the language in the law and we looked at the language in the standards as far as what the federal PREA standards define as behavior, and they match. So whether they need to stand alone and not be connected to the juvenile law, there are other people who that is their job, that's not mine, but it does match the behaviors that we need to tackle.
Okay. So it solves the problem, even if it's in a bit of a mess.
Yes, because the biggest issue that we've encountered is the law is so prescriptive to penetration.
Mm-hmm.
And again, if we have same-sex relationships, that's not always penetrative in nature, and it doesn't include the other behaviors leading up to.
What does Mississippi do?
As far as how
do they have a similar law, or would be?
Yes.
If a offender is in Mississippi, what is the ability in Mississippi? I realize the act would happen in Mississippi and be dealt with in Mississippi.
Yes.
But are their laws similar to this, or are they similar to what we have now?
So their laws are similar to this, as most states are under PREA. Most states adopted whatever version, whatever you want to call it, but a sexual assault law to match what the federal PREA standards require.
Do we have a model from other states that we can?
You mean what in?
I think the committee is, Senator,
Well, can I just add something on that, which is that, so something that keeps getting discussed is that it's messy by having to pull the sexual act definition from chapter 72 and the sexual conduct definition from chapter 64. And I think everybody is in agreement about that, but those are the terms that are used throughout Title 13 and kind of the realm in which you're working with. And so in terms of whether it was you guys making a decision point on S-278 on comparative negligence, or the House Judiciary Committee making a decision with regard to this bill, both times the decision was to say, this is what we have. This has highlighted an issue around terminology that should probably be looked at holistically, but not not bill by bill, but let's use what we already, what practitioners, stakeholders, everybody is using now to try to address the legal issue that's before you, recognizing that there, in some future year, may be a much better way to hone the definitions to specifically address in all of these different issues, but that's a bigger task than doing it on 278 or doing it on this bill.
So I understand that, but my question, I guess, had to do with Mississippi, since we have 100 plus offenders in Mississippi. And if this behavior occurred in Mississippi, it would be dealt with like this.
Correct.
Even though the terminology may be different and the bill,
Correct.
the law may be different. So, in other words, there's more protection in Mississippi right now than there is in Vermont. Would that be accurate?
I don't know that I would agree with the word protection, but I would.
Well, more ability to prosecute.
I potentially, yes. Greater consequence for the act, potentially.
Accountability.
Yeah. And I don't know if I need to say this or not, but I know a lot of the conversation was around COs and POs, and I want to make sure that we're being very clear, it's for all corrections staff.
No, I
because-
understood.
Okay, all right, cool.
But I would, my concern was more about making sure that we're consistent where the person is held. So,
Just to clarify really quickly, the department, as Jen noted, and Jen is our resident expert, of course, we think that the 28-21 definition very closely matches the pre-definition. So that would help us create that statutory congruency. Where things got a little bit complicated with the multiple definitions we were hearing about was in-house judiciary, where there were questions around the intent language. And I know Tim, State's Attorney, can speak a little bit more about that. We understand that adding intent language might make it a little more difficult to prosecute some of these cases. That was the concern of the House Judiciary Committee. Our opinion is that the Department of Corrections, at a minimum, would like to see the 28-21 definition to create, again, that congruency with federal law. And around intent language, again, intent language is included in the section 115.6 pre-definitions that you have in front of you.
okay. Senator Baustein and Senator Sheen.
I have a question that is
Okay, I thought you.
backtracking a little bit, and I think it may be for Michelle. Under our current statute, would it be illegal for a physician treating, say, an inpatient individual at the Brattleboro retreat to engage in a sexual relationship with that individual?
I think not unless it fit under the kind of coercion or force or something other aspect of that. I mean, I think as long as the person has reached the age of consent, there's not force or coercion involved. There's not a relational prohibition on that, the way that there is like with the sexual exploitation of a minor, where you have like, the crime if it's a 16 or 17-year-old engaging in a sexual act with someone who's 4 years older, at least 4 years older, that kind of thing.
And thank you. And I ask, again, we're talking about someone's freedom, and I wonder, I don't want to hold this bill up, but I do actually think that we might want to think about a broader scope. If someone is held against their will, because you can hold someone in a psychiatric setting without their consent, I think this should also apply in those instances. That to me is different than, say, my primary care doctor having a ill-advised relationship with a patient versus a patient who is held and cannot leave. So I think there may be space for some expansion on this, actually.
And my area of responsibility is with the adult prisons and jail standards, but the PREA standards also apply to community confinement as well as juvenile. And within the standards, they do define a mental health component. And so, for example, the state hospital, Brattleboro Retreat, when we had Woodside, those locations, the standards apply to confinement as a setting, not a prison or jail definition. And so the standards do address that those places should be held to the same standards.
I wonder if we can add that aspect into this bill, especially given that it sounds as if it might be germane, given that PREA addresses those situations, because I do think there is, in those instances, also a liberty issue at stake that is different.
I mean, Michelle?
I just wanted to clarify, and I think I kind of missed the aspect about thinking about it specifically at Brattleboro Retreat, is that, depending on who the purported victim is. I mean, there's issues around consent, and we have very, and you guys did some considerable work on what consent means a few years ago in a big sexual assault bill. And so there's the analysis there about whether or not the person has the capacity to consent. So, but in terms of it, just, if you have someone who is able to legally consent, engaging in a relationship with someone, so I think, there's a lot of nuance there around this. Is someone involuntarily committed? Do they have the ability to consent? There's a lot of things in that piece. I'm sorry, I was thinking more of like just the physician treating a patient.
So 17-year-old at 204 Depot in Bennington has a relationship with a staff member. It's consensual, but that's inappropriate because the staff member has power over a 17-year-old. Are they covered by this law?
I think whether or not, I don't know enough
Or
about
are they
the
already
regulations, but
covered by?
if you look at the sexual exploitation of children, statute right there of a minor, I think if the staff person at 204
Because they have
Depot,
a power over that.
yeah, if they're 48 months apart and they fit within that second part of the test, then that would be a violation of that.
But current law
Right, under current law.
doesn't provide that if the person is 21 and it's a staff member in the Department of Corrections supervising them in the community. Is that what the problem is we're trying to solve?
Well, the issue specifically with DOC is that it prohibits sexual acts, but not sexual conduct, so the masturbatory
Right, no, I
acts
know,
and things
but
like that,
if it's
correct.
sexual conduct
Uh-huh.
and it's a 21-year-old offender
Mhm.
being supervised by a 30-year-old probation officer, and they're involved in a sexual conduct,
Mhm. That
this
would not be
bill
covered.
would.
But it would be, but
It
this
would be
bill,
if this bill passed.
correct.
Yes.
Okay, that's all I'm trying to get.
Correct.
There's no.
And it's the same
component.
thing with
Yeah.
the 204 Depot and.
Right, but that's already covered because all the kids are under 18.
Well, no, because the sexual exploitation of a minor also uses only the term sexual act and not sexual conduct
Okay,
as
so
well.
that
So if you
changes this
had,
there.
correct, so it's the same policy change in both places.
Okay.
Is that you're extending it beyond and be like in a sexual act involving.
We may come up with everybody who likes this bill, but nobody wants to report it.
I mean, I'll do it.
Did you have a question?
I did, and it's sort
For
of,
Jen or for Michelle?
thanks for
I
Michelle.
wanted to, if we have any more questions for the witness, I wanted to excuse the witness. in this.
Well, I guess my question for the witness would be if DOC would support a bit of an expansion of this to make sure it covers those sort of inpatient psychiatric type instances.
My answer as the resident CREA expert is that we would support any language that ends up with the state being congruent with all the confinement standards that are required by the feds.
Perfect.
How's that for a not answering?
That was a great not answer answer.
Actually, that's a very responsive.
Yeah, that was great.
Jen, thank you very much.
No, thank you.
Tim, did you want to testify on this?
Yeah.
On the schedule?
I actually was on page 2. I also didn't catch it
Well, I
myself.
lost page 2.
I
Is it, my schedule goes right there.
Oh, yeah. look at
I have
that.
very brief testimony, if that's helpful,
Okay.
because you've heard from
Huh?
folks as well.
You cut him off. Oh, yes, it is. It is way at the top. Yeah.
I did still have a follow-up for Michelle, kind of in line with what we were previously talking about and like who's covered under current law and who isn't. And so if I'm a 20-year-old and I have gone through diversion, and one of the things that I'm required to do to complete that diversion program is mandatory substance use treatment at Brattleboro. And a physician at Brattleboro engages in a sexual relationship with me while I'm there. Is that covered under current law or would we need to somehow lump that in?
Wait, so you're
I'm 20 years old.
20 years old, you are in a mandatory programming. I don't think there's anything in statute. I mean,
So it would be perfect.
I mean,
Acceptable, well, maybe not acceptable.
right, I mean, unless you, again, violate one of the things around, there's clear lack of consent, you're not able to
Yeah.
consent,
Okay.
there's, force or coercion or threats involved.
Okay.
But if it was, if it was outside of that, then there's nothing.
Okay. Thank you.
And Tim Leader, Department of State Attorneys and Sheriffs. Yes, the sexual assault statute would cover fact specific, as Michelle said for sure. Just would depend. There's also for under 18, there's the entrusted care sexual assault too, and that would be fact specific as well. If you were by law actually caring for somebody, that's another circumstance, if I'm not mistaken. So yeah, my brief testimony on this is I'm here to offer something else, which is that I think that this is a very simple bill. Yes, the definitions are, I'm not going to say messy because I actually think this is a simple, helpful bill. And I think for the purposes of just clarifying these three areas of law, I posted a brief memo on the page. I think it's helpful to include both definitions right now, sexual acts and sexual conduct, because within sexual conduct, there's one portion that requires intent. And so in that way, it's narrower than sexual acts. So if you include both definitions, for now, it covers the scope of both. And sexual assault, for example, some of the things you were just talking about is sexual acts, right? So that's its whole thing, and maybe it's broader, maybe it's narrower on depending, but if you just include both definitions for these three areas, sexual exploitation of those under the care of DOC, law enforcement, those being investigated, detained, arrested, or in the custody, and sexual exploitation of minors, you're making this very helpful fix that would eliminate a discrepancy in how these sort of exploitation context sexual crimes are occurring. And what's awkward about it is that when we're even describing sexual acts, we're using the word sexual conduct, and when we're describing the word sexual conduct, we're using the word sexual acts. So there's some semantics there. But sexual behavior and the prohibition on tips of sexual behavior is really how I would talk about this and eliminating a discrepancy. So on the memo I posted on your page, I said, here's the current law, here's what you would change, here's the current law, here's what you would change in those three circumstances. And so we're in support of this bill, and actually right before testifying in the House, John Campbell, our executive director of his office, said, Tim, come in my office. There's one circumstance where this is narrower, and he was right, and I had missed it before going into House Judiciary. So that's part of the reason that there was that change there, and I think that it's a helpful and simple fix for right now. Happy to engage in another discussion on redefining all the different pieces, and there's also, not included here, but I included on my memo, sexual act is something that we've been talking about today, but then there's also sexual activity defined in the similar section, and then sexual contact, which is in the lewd and lascivious piece, which is actually a moving target because it depends on what's happening, community norms, et cetera. So lots of pieces here. In favor of this bill, think that it's helpful in eliminating a discrepancy.
Senators, can I add something while Tim is still there? And I just wanted to fill y'all, and I think I might have mentioned it before, but and I know you'll probably remember, but I don't think anybody else maybe was here on the committee at the time. But so Vermont has a human trafficking law, and a number of years ago, when Judge Treadwell was head of the criminal division at the Attorney General's office, he approached this committee because they were finding there to be issues around using the statute for prosecution for human trafficking involving sexual acts. There were certain cases where they found that people were operating massage parlors, and because the use of only the term sexual act in human trafficking law in Vermont at the time, there was conduct that was occurring at these massage parlors that did not fit that definition, and therefore the state was not able to pursue those cases. And so the Attorney General's office came to this committee, and I think maybe Senator, I think maybe it was your bill, and the legislature expanded the human trafficking law to include sexual act as defined in 3251 or sexual conduct as defined in 2821, which is exactly what you're doing here. So I just wanted to let you know, I know people don't love it by using those two terms, but you do have precedence in this. So
I wouldn't describe it as messy myself. It seems convenient. that we're using existing definitions and we're just saying we want the aggregate, not.
I think that's the thing, is because these definitions, however perhaps imperfect from various people's views, is that they have been there quite some time and they have established case law and practitioners know what they mean. You know, it certainly doesn't mean that you can't look forward and say, could things use an updating, or could we approach this better? But there is a, you know, from several years ago, you have precedent of you guys expanding from sexual act to include sexual conduct and then moving forward with that.
I would have no objection to asking the Sentencing Commission. I'm not sure how to word it, but to look at simplifying, or maybe that's not the right word, combining laws regarding sexual conduct and sexual act, and how they can be more streamlined and more understandable. And I think you pointed out with your memo here that Senator Bausch gave a question.
Yeah, I certainly don't want any of my comments to sound like I am opposed to moving forward in this way. What I'm recognizing is this is the second time just this session we've had to go look at multiple different places in existing law to define what we mean to define. And so I would be really supportive of the Sentencing Commission looking at a underlying sort of cleaner way to just define what we want to define, as opposed to having to grab things from multiple places in statute. I think this is, given the construct and the confines of what we have, this is a neat, clean way to do what we want to do. But I think that we could create a neater, cleaner way going forward to just define what we need to define.
I've just asked Michelle to do an amendment that would add the Sentencing Commission looking at those three
Prohibited sexual behaviors.
Yes.
Yeah, right.
prohibited
In
sexual.
context.
And maybe if anybody has any thoughts on how to help Michelle with what we're trying to look for,
Is
we
the
can
network,
spend the next few. Are there any other questions?
Oh, sorry.
Tim, thank you. Your memo is very helpful.
Thank you, guys.
Senator Steves, is the network on the Sentencing Commission?
Yes.
Okay, perfect. I just want to make sure they're involved in this conversation. They
I
seem like a
believe
really
that
important
would be part of
stakeholder.
the Sentencing Commission.
I'm not sure that they are, but last year they consulted.
Well, the
Yes.
victims,
Jen Pullman's
Jen
CCBS,
Pullman's.
but they consulted last year on
Okay.
a couple things, so you could.
well, we could ask them.
Yeah, I just think they would have a really important
And
viewpoint on this.
state employees as well. All right, is there anything else on this board that we want to look at? So Michelle, if you just came back next week with an amendment to add a look by the Sentencing Commission at the crimes, I think we're in